Hello, I'm Shannon Larkin with Harmony Healthcare IT. Thank you for joining us for this webinar where we'll take a look at the legal and retention issues with electronic health records. Today's webinar is a result of a white paper that was co-authored by Harmony Healthcare IT and Warner, Norcross, and Judd. That white paper, along with the recording of today's webinar, will be available for download on either company's website. You can see it here at healthdataarchiver.com. Just click on Resources, and you can download the paper, and then a recording of the webinar will also be available on this page. Just a few other quick housekeeping notes for today. The webinar content will last for about 25 or 30 minutes, and after that we'll follow up with some Q&A. So if you have any questions, you can write them down in the question box on the GoToMeeting screen. And then if you have additional questions or would like a follow-up discussion with either of our presenters today, you can let us know and we will contact you. Both of their contact information will be available on the last slide of today's presentation. So with that, I am happy to introduce today our presenters, Jim Hammer from Harmony Healthcare IT and Jay Yelton from Warner, Norcross, and Judd. Jim and Jay will provide insights that we hope will get you thinking about how your organization can be best prepared for legal issues associated with health record retention. So with that, Jim, I'll turn it over to you.
Thank you, Shannon, and to those able to join us today. My name is Jim Hammer, and I lead Harmony Healthcare IT's product and services teams. I have the distinct pleasure of working with some extremely talented team members that focus solely on healthcare data management daily. Harmony Healthcare IT has been around for just over 10 years. We started in the revenue cycle, health information exchange, and interface services businesses. Most of our leadership team came from enterprise practice management and EMR development and implementation services. When healthcare consolidation started, we quickly saw a need to assist the healthcare entities with meeting data retention requirements and have developed a suite of services and an archival application that's easy to use and allows for eDiscovery requirements to be met. To date, we've helped hundreds of customers with consulting and prioritization of how to tackle the difficult process of archiving and decommissioning legacy applications. From single providers to the largest healthcare institutions in the U.S., we've helped many through this exact process that we'll be discussing today. I look forward to our discussion, and at this point in time, I'd like to hand it over to Jay Yelton.
Thank you, Jim, and good morning. I've been a litigation attorney for 30 years now. I'm currently a partner at Warner, Norcross, and Judd, and co-chair of our firm's Data Solutions Practice Group, which includes 30 professionals that specialize in the legal issues associated with organizational data. Those legal issues primarily include records and information management, data security, data privacy, and eDiscovery. eDiscovery is the core area of my practice, and it includes the preservation, identification, collection, review, and the production of data and documents in response to litigation, government audits, government investigations, and as well as non-party subpoenas. We created this Data Solutions Practice Group a couple of years ago for two main reasons. One, we noticed that our clients were increasingly having to deal with these type of data organizational issues. And two, there is a need for coordinating on how to most effectively and efficiently deal with these issues. That coordination is important both for us as a law firm as well as coordinated response for an organization in-house. For example, if an organization adopts a BYOD policy or allows its employees to work from their home computers, it impacts all of these legal areas. It impacts the privacy issues, impacts data security, certainly impacts eDiscovery when data has to be collected for litigation or a subpoena, and it also includes or impacts records and information management. How long is something going to be kept and when should it be deleted? As a consequence, a coordinated approach or solution is needed. Jim, if you don't mind, next slide.
Shannon, I think you got control of the slide.
Let's see. There we go. Perfect. The data solutions issues that I've mentioned impact certain industries and organizations more than others. The two industries most impacted by these issues are financial services and healthcare. As this slide reflects, it is no secret that the electronic health records industry is on a rapid growth trajectory, and it involves a lot of players. Next slide. Today we hope to cover three main topics. I will be covering the first topic of mitigating legal risks. I will explain that one way to significantly reduce legal risk is to be prepared for eDiscovery before you are served with litigation or a non-party subpoena, and before you learn of a likely government audit or investigation. Jim will then cover the second topic of retaining data and replacing systems. He will explain the kinds of data that needs to be retained and the main issues with long-term legacy data management, especially in the case of system replacement. Jim will also cover our final topic of governing data with technology. He will discuss the importance of a cross-functional team to define a long-term data management plan, which uses technology to secure records in a searchable and HIPAA-compliant format. Next slide. With respect to the first topic, let's discuss why eDiscovery risk and costs are so significant. As I mentioned before, the word eDiscovery includes several stages set forth in this slide: data preservation, identification, collection, data review, and finally production. These eDiscovery stages are the most time-consuming and expensive components for most litigation cases and government audits and investigations. Why is that? Well, let's focus just on the first stage for a moment: data preservation. The law is very well established in every state in our country that when an organization reasonably anticipates a lawsuit or government investigation, the organization has a legal duty to take reasonable steps to preserve potentially relevant data. Well, 15 or 20 years ago, compliance with that duty to preserve was not a major hurdle for organizations. That's because organizations had a lot less data 15 to 20 years ago. That data was in fewer locations, and the data was largely hard copy records. Today, compliance with the duty to preserve is much more complicated. In addition, the sanctions that courts impose on parties who fail to comply with the duty to preserve are much more substantial. If you are the plaintiff and you fail to preserve relevant data, your case could be dismissed. If you are the defendant and you fail to preserve relevant data, a default judgment could be entered against you. Large monetary sanctions are also quite common. And a fourth type of sanction is called an adverse jury instruction. That is where a judge will instruct the jury at the end of the case that your organization had a duty to preserve on a certain date, that your organization did not take reasonable steps to preserve relevant data on or around that date, and that relevant data was deleted, and that the jury should assume that that data would be adverse to your position in that litigation. Obviously, that type of adverse jury instruction at the end of a case is very detrimental to organizations and often will result in the end of the litigation because a party is too fearful to have to go to a jury with that type of an instruction. I just talked through some of the increased risk and cost during the data preservation stage, but the same is true for each of these other eDiscovery stages. As the quantity and locations of data increase, the risk and cost of identifying, collecting, reviewing, producing data will also increase. Many people get frustrated by the fact that these eDiscovery stages can be so costly, especially when you consider that roughly 1 page out of every 1,000 pages produced is actually important enough to be used as a trial exhibit. Next slide, please. As this slide reflects, eDiscovery has become the top litigation area for increased spending. It has become the top area for increased spending because if you don't adequately manage your data, costs can easily get out of control. For example, a few years ago, the Office of Federal Housing Enterprise Oversight received a non-party subpoena from 3 defendants to provide records related to its oversight of Fannie Mae and Freddie Mac mortgages. The office filed a motion to quash or limit that subpoena. But because the office was unable to adequately define the scope and burden associated with their compliance with that subpoena, the court denied their motion. However, the court did give the office 4 months to comply. Because the office provided an incomplete production of data within those 4 months, the defendants then filed a motion for sanctions. In response, the office committed to search again for the requested documents, and they agreed to allow defendants to identify search terms as a means to identify those responsive documents. Defendants provided the office with a list of more than 400 search terms. When they ran those search terms, over 500,000 potentially responsive documents were identified. The office had to hire 50 contract attorneys to review those 500,000 documents, to confirm responsiveness, and to redact privileged information or to withhold privileged information and to put it on a privilege log. Despite spending $6 million in this compliance effort, the office was still unable to meet the court's deadline. As a consequence, the court held the office in contempt and ordered the office to produce the rest of the documents without even doing a privilege review. Well, what are the lessons you learn here? When you maintain too much information and you can't quickly assess and the cost and burden of searching that data in response to discovery, you risk this type of discovery nightmare. And that may even occur in a case like this one, where it was a non-party subpoena, where the office wasn't even directly involved. So, but the good news about this is that what we're about to provide you today are some tips for managing those costs and risks. And the good news is that these tips are really quite simple. However, I do want you to note that these tips are proactive in nature. For purposes of this slide, the tips really should occur at the bottom of this large white arrow. In other words, they involve steps that should occur before litigation or a government audit investigation is reasonably anticipated. Next slide, please. Tip number 1, get rid of redundant, obsolete, or trivial data, otherwise referred to as ROT. For most organizations, ROT represents between 30 to 70% of the data they maintain. Why is that? Well, several studies have determined that the same data is maintained in 8 to 12 locations. It's not surprising when you think about how much now organizations rely on email, and just mere sending of one email to 2 or 3 different people really results in that email being located in multiple servers, on multiple hard drives, and possibly multiple personal devices. So getting rid of the duplicative copies alone is a very simple way to reduce future likely cost and risk. Tip number 2, conduct audits. This is important for several reasons. For example, when litigation, an investigation, audit, or subpoena arrives, the time period in which a response is due is very quick. In fact, the new federal rules of civil procedure that were just amended and became effective in December of 2015 reduced the time frame by about 40%, by which a party needs to be able to describe the data that they have and be able to articulate the cost and burden associated with compliance. Audits will help you know what you have and where it's at, which is an invaluable foundation for when litigation, investigation, audit, or subpoena arrives. For example, a current audit would have been very valuable a few years ago for the Office of Federal Housing and Enterprise Oversight. They would have been able to define their cost and burden at that first hearing instead of going through the steps that they did and accept 400 search terms, which resulted in a collection of documents that was way more than what should have been done in that particular case. Tips 3 and 4 are related. Maintain a solid retention schedule and preserve records for the proper length of time. Why is this important? It's important because the quantity of data in an organization is doubling every 18 months. As a consequence, it's very important for your employees to know if they're to keep the data, and if they are to keep the data that they've created or received, how long are they supposed to keep that data and where? Also, an updated RIM policy is very important for providing employees with explicit and simple guidance on how they're to comply with creating, receiving, maintaining data, and for the length of time that they need to keep it. Tip number 5, a solid legacy data archive is critical for several reasons. Regulatory compliance. It also is for business value. And what I mean by business value is one of the greatest assets for an organization is the things they've learned in their business, in their industry over time. It is important to maintain that historical information for potential future use. On the flip side, not to create too much data, and how to identify and archive the important information is key. And number 3, discovery compliance efficiency. The final tip is avoid unexpected expenses by careful planning. For example, data breaches or inadvertent release of personal or private information will result in unexpected and substantial expenses. For example, data breaches are increasingly common for both small, medium, and large organizations. In fact, in the United States last year, the average cost of a data breach was $230 per record, and the average breach cost as a whole for a company was $6.5 million. By following these tips and reducing rot and organizing and archiving the key information and following these other tips will help you reduce this type of risk and these type of costs. I'm going to turn it over to you.
Thanks, Jay. Up in Jay's group, as well as ourselves, we're asked the question, how long must data be kept? As most of you know, a number of statutes and regulations impose a duty to preserve medical records. Institutions and practitioners are subject to HIPAA and are required to preserve documentation related to their medical records for a period of years from the date of its creation or the date of which was last in effect, usually whichever is later. About half of all states require a retention period of 10 years for medical records, while many states impose retention periods between 5 and 7. The American Health Information Management Association, HEMA, adopted retention requirements ranging from 5 years for diagnostic images to permanent retention for registers of surgical procedures, blood bank data, and other record types. Ultimately, there's a broad responsibility to preserve medical records. In most states, that duty is for at least 5 years. Others require periods of up to 10, and still yet others up to 25 or perpetually. Next slide, please. We're often asked, what are best practices that support efficient eDiscovery? I'll give you quite a few here. First one's cost reduction. Streamlining the long-term storage of historical PHI now will save money in the long run. Not only will it reduce costs paid for the support and technical maintenance of an antiquated system, it will save on training of new staff on how to access information over the next 7 to 25 years. It also minimizes risk. Preserving historical patient data is responsive to every provider and health system. As servers and operating systems age, they become more prone to data corruption or loss. The archival of patient data to a simplified and more stable solution ensures long-term access to the right information when it's needed for an audit, for legal inquiry, as well as patient care. Incorporating a data archive can also avoid the costly and cumbersome task of full data conversions. Next item is compliance. Providers are required to retain data for nearly a decade in most cases, or past the date of service. You should check with your legal counsel, your HIM director, medical society, or a HEMA on medical retention requirements that affect your institution for further guidelines. Archival also simplifies access to your data. We all want data at the touch of a button. Gone are the days of storing historical patient printouts in a binder or inactive medical charts in the basement or storage unit. By scanning and archiving medical records, data and images, as well as archival of electronic medical records, it becomes immediately accessible to those when, where, and by whom it's needed. And last, archiving allows for the merging of data silos. Usually decades worth of data from disparate legacy software applications are available for immediate access via any browser-based workstation or device. Also, medical document scanning and archiving provides access to what are once paper charts. We often also run into a lot of times where, again, there could be 1 to 15 different systems where the HIM and folks pulling records have to search and produce records for eDiscovery. An archive allows that to be consolidated into a single location. Next slide, please. How should you plan to meet eDiscovery retention requirements? First, maintain a solid retention schedule. You should involve your legal, compliance, IT, and other key stakeholders to ensure that the plan meets your enterprise, local, state, federal, and other governing body requirements for what needs to be retained and for how long. Next, utilize available technology tools to create a plan for the future with a searchable data function for historical records. An archive solution certainly helps easily achieve that goal. Plan to eliminate redundant, obsolete, and trivial or rot data. At this point in time, when you're going through the archival process, it's a great time to review what data needs to be kept, filter and remove data that doesn't, and archive only what's needed for eDiscovery. As with most implementation, Calorama's report says that approximately 80% of the work must be spent on issues of change management, while only 20% is spent on technical issues related to the technology itself. As you know, moving someone's change is difficult. You can help with that change management with a strong governance team and demonstrating an archive solution early and often during the implementation process. Remember, some of the users have been using these systems for 10, 15, or even more years, and letting go of those systems is certainly challenging. Next slide, please. What are some other considerations to think of? First, you can incorporate new standards as they relate to the digital world of EHRs. Example of that is remote hosting. When a lot of these systems were stood up, the only option was to put it in a data center or a local under-the-desk or server room at a facility. Remote hosting is certainly a viable option today. Additionally, you can create limited logon provisions for the legal discovery, where that might have not existed in the original source system itself. Continue to evolve the commonizing of key patient data for exporting and sharing of data with systems and providers. A good example of that would be to utilize or create naming conventions that are standard across all source systems being archived. As an example, prescriptions might have been named RX or medications in source systems. If you can standardize on, as an example, medications going forward or whatever your go-forward system is, it makes eDiscovery much easier, much faster, and more efficient when that data is needed to be found. Last, consult with industry and legal experts who have successfully completed numerous system replacement migrations and extractions before. You certainly don't have to be a pioneer in this area. You can take advantage of best practices of your peers who've done it before. You're certainly not alone and have the access of others that have done exactly this process before you. At this time, that's the end of our formal presentation, but we'd certainly love to open it up to questions from the audience.
Great, thanks Jim and Jay. Like I mentioned at the beginning of the broadcast, you can use the question panel on GoToMeeting to submit a question. We do have a few here for you. The first one, Jim, is for you. It says, our healthcare organization has changed our EHR system. It has several old systems running in maintenance mode. Isn't that good enough?
That's a common question. First thing, in smaller practices, usually the fear and why it may not be enough is to look at the age and the cost of that legacy application. From a risk perspective, things like, is it running on a 2003 server that may be open to hacking or virus, as an example, or as mentioned, the cost simply is prohibitive to keep that legacy application running, when archive might be able to solve that for you. On the larger enterprises, it's not uncommon to run into 5, 10, 30 different legacy applications that need to be retired. In that case, it's a monetary as well as ongoing kind of sunk costs that can be removed. Things like just keeping folks trained on those legacy applications. A lot of times we're asked, folks don't necessarily know how to access them after a period of time since they've gone live on their go-forward application suite. So a lot of those items certainly kind of come to bear where keeping those active individually are certainly not advantageous.
Okay, great. And this one looks like it comes on the heels of that last question. If we change EHRs again in a few years, does an archive continue to grow with our legacy data needs?
Another great question. One of the key advantages of an archival solution should be the centralization and easy access to disparate legacy application data. So as an example, with our solution, a user, as long as they have provisioned rights to be able to see the data, can see as many systems that we archive from one single central application screen, which makes, again, access to that data efficient, whereas before they'd have to log in and access multiple systems and, again, retain the knowledge of how to get to the data for printing or generation for eDiscovery across each of those. An archival solution certainly can consolidate that to a single location.
Great. I think, Jay, the next question is for you. Is it important to have a legal audit of our EHR policies and practices?
Yes, it is, and it's becoming more so as time progresses here. And the reason why, or at least one of the reasons why, is because an organization's policies and practices with respect to their data and records is discoverable in litigation. How it typically will play out is discovery will be requested. You comply with discovery by producing document and records, and typically the other side does not believe that your compliance is sufficient. There should have been more information there, and so they start challenging the effort one has made. In doing so, they will often, increasingly as well, ask for the organization's records or their policies and practices, especially with respect to retention. And that's because typically the organization says we have no more, and the reason we have no more is a lot of our old records have been destroyed pursuant to our policies and practices. So in this litigation or in government investigation, they're going to ask for those policies and practices. And courts almost routinely will grant that type of discovery. And why is that important? Because there's only one thing worse than not having policies and practices. It's having policies and practices which your employees are not complying with. And so, in my experience as well, is when you're dealing with policies and practices and you have multiple employees, especially with respect to data policies and practices, you're going to have a lot of inconsistency on how employees actually implement those policies and practices. So that legal audit will allow you to identify variations in compliance and to then tailor some educational programs to your employees so you get some more consistency. And I also think the legal component of the audit is important because, as we mentioned before, the more your preferred legal counsel is aware of your data systems, they're going to be in a better position to narrow the scope of discovery early on in a case or investigation, and they'll have the information they need to establish burden and cost.
Great. Great. It looks like we have one last question also for you, Jay. Which federal rules of civil procedure were recently amended that impact an organization's need to identify and produce discovery data more quickly?
There was probably about 10 or 12 total rule amendments, but 3 of them really relate to this particular issue. Rule 16b-2 was amended to reduce the time frame after a case was filed to when you're going to appear for a scheduling conference with the court. It has been reduced from 90 days to 60 days, and why that's important is that pretrial scheduling conference, there's going to be a lot of issues discussed at that conference relating to discovery, and in fact another portion of that amendment provides the judge a couple more topics, which are discovery topics, that should be discussed at that conference. And to the extent that an organization wants to get control of the discovery process and reduce the scope, bringing those issues up at that time is very, very important. The second rule that was amended was Rule 26D2, and that again is one that has expedited discovery in a federal case. It used to be that you would not be able to file a request for data until you had that pretrial conference. That's no longer true now. These requests for production can be filed 21 days after the lawsuit is filed. So again, it's speeding up that process by which an organization is going to have to understand what data they have and what they may have to produce. And maybe the most important one is Rule 26B1. And this is really quite a valuable amendment to organizations, because what it explicitly states is that the amount of discovery that is going to be permitted in a case needs to be proportional to the needs of that case. And it lays out several factors in helping a court decide. And what the goal of this is we're not going to have $1 million in discovery for a case that's worth $200,000. Now the key here is, how do I know that the discovery is going to cost $1 million? How are you going to be ready to make that argument to the court that it's not proportional? Just going to the court and saying, Your Honor, this is way too burdensome or way too expensive without facts is not going to win the day on a motion or on an effort to reduce the scope. The key is to be able to articulate early in the process, what is the cost, what is the burden, and then this rule change gives you the tool to reduce the scope of cost in just the scope of discovery in general. And but again, it behooves you to be proactive, follow some of these tips, so you and your counsel is in a good position to make these arguments early in a case.
Great, thank you, Jay. And that was all of the questions that we received today. So I would like to thank everyone for joining us today. And as I mentioned earlier, here's the contact information for both of our speakers today, Jim Hammer and Jay Yelton. Thank you both for joining us. And I appreciate your time.
Thank you very much.
Thank you.